can go back on the record. Staff, do you have any cross for this witness?
No, Your Honor.
Walmart, do you have any cross for this witness?
No, Your Honor.
Potomac Edison.
No cross for this witness, with the exception of follow-up to any questions that the bench has.
I have no questions. I thank you for your appearance this morning, and you can be released.
Thank you.
Office of People's Counsel.
Yeah, Your Honor, I believe that these have been excused.
Yeah, I think so. Did we enter in their testimony already? I don't think that we did.
Your Honor, I believe that we entered, and if Your Honor may verify, but I believe that Mr. Colton's testimony is
Oh, 1 and 2. You're
1
right.
and 2, and I believe you have Ms. Lane as 3, 3C, and 4. Is that accurate?
Yes, that is
Thank
accurate.
you, Your Honor. So I believe we are on to Mr. McAuliffe.
So OPC rests.
Well, we don't rest because we do have witnesses that are going to be heard next week.
Okay. Thank you for keeping me straight.
Sure.
Staff.
Thank you, Your Honor. We need to change attorneys, but staff would call Drew McAuliffe to the stand.
Excellent.
No, just been limping all week. I sprained a tendon in my foot Monday.
Your Honor, if we may just make a quick call to our co-counsel, who was, thank you, Your Honor.
Oh yeah, I was at the
There was a head fake. He faked this out for real. There's a no-look pass. It's your prerogative. I just thought you would have some. No, that's fine. Okay, maybe I should get out of the way.
Your Honor, Mr. Alexander is handling any cross-examination of Mr. McAuliffe, and he's on his way down. If we could ask for the court's indulgence for a few moments. Yeah. Thank you, Your Honor.
I do. Drew McAuliffe, DREW MCAULIFFE.
Your witness. Hang on just a second, counsel.
Your Honor, we did get a message from someone who's watching that the video feed had stopped, but it may be remedied now. It was a few minutes ago, maybe?
Yeah.
Okay.
It did stop. I got a message too.
Okay.
It did stop. It is back on. You're gonna see me keep glancing at this computer to make sure that we don't have any other technical issues. Please let me know if you get a further message. Just interrupt me right away, because that's one of the things I'm supposed to do is keep us.
Thank you, Your Honor.
Okay, go ahead, counsel.
And
Oh, go ahead. Okay. So I just wanted to confirm that we entered Staff Exhibit 1 and 2 into the record. Staff Exhibit 1 being the incentive plan, First Energy incentive plan, and Staff Exhibit 2 is a short-term incentive plan.
Yes, staff in 1 and 2 are in the record.
Mr. McAuliffe, can you please state your name and business address for the record?
Yes, Drew McAuliffe, 6 St. Paul Street, Baltimore, Maryland, 21202.
And by whom are you employed, and what is your position with the, I'm sorry.
The Public Service Commission, I'm the director of the Electricity Division.
Do you have with you a document entitled The Direct Testimony of Drew McAuliffe, consisting of 59 pages of narrative text and 4 exhibits?
I do.
And do you also have with you the surrebuttal testimony of Drew McAuliffe, consisting of 16 pages of narrative text and 1 exhibit?
I do.
And have these documents been pre-filed in this case?
Yes.
Was this document prepared by you?
Yes.
Do you have any additions, deletions, or changes that you would like to make to this document at this time?
I do not.
Do you adopt this document as your testimony, as your direct testimony and surrebuttal testimony in this case?
I do.
Your Honor, I would ask that Staff Exhibit 1, I would ask that Drew McAuliffe's direct testimony be identified as Staff Exhibit 3,
Staff Exhibit 3 is marked.
and that the surrebuttal testimony of Drew McAuliffe be identified as Staff Exhibit 4.
Staff Exhibit 4 is marked.
At this time, I'd like to move Staff Exhibit 3 and 4 into evidence, subject to cross-examination.
Any objection? Staff Exhibit 3 and 4 are admitted into the administrative record. Go ahead. Yes, absolutely.
Sure.
The witness is available for cross-examination.
Walmart,
No cross, Your Honor.
OPC,
No cross, Your Honor.
Potomac Edison.
Yes, Your Honor, I have a few questions.
Great.
Thank you. Can you hear me clearly? Hi, Mr. McAuliffe. How are you doing this morning?
Good, how are you?
Good, good. Mr. McAuliffe, I'll just jump right in here. Would you agree with the statement that if a utility is not able to attract capital, that utility might not be able to fund the construction and maintenance of facilities that are needed to provide safe and reliable service to its customers?
Could you please repeat that?
Yeah, would you agree with the statement that if a utility is not able to attract capital, that utility might not be able to fund the construction and maintenance of facilities that are needed to provide safe and reliable service to its customers?
Yeah, sure. Generally, yes. If a utility cannot, issue debt or gain equity in any way, yes, it could be difficult to construct facilities.
So to extend this line of thinking a little bit, would you also agree that a recommended return on equity should be set so that it allows the utility the opportunity to earn returns that investors may expect to earn from a company with similar business characteristics?
I would say a utility needs to earn a fair equity that is commensurate with companies of similar risk. That's, for example, why we have a proxy group of utilities to determine the ROE of PE in this case.
We're on the same page. That's a good thing. So in other words, the return on equity is the number investors may use to determine whether or not they would invest in a company, right? So if you're an investor, you're looking at your proxy group of companies or companies we might put money into.
Mm-hmm.
We're going to take a look at which ones might give us the best return on that investment, wouldn't they?
Sure, yeah. Investors look at a lot of factors to determine whether they, choose to invest in a company or not.
Right. So too low a number, it's not, the juice just isn't worth the squeeze. I'm not going to put my money in a company with a low number. I'm going to look for a company with a bit higher of a number.
It's possible, but yeah, there's multiple ways to determine what that number may be. Investors look at a lot of characteristics. What type of business they're in. If there's any kind of ongoing legal issues, it could be a myriad of different factors that they look into.
And that's a really good point. You're talking now about risk, right?
Mm-hmm.
How much risk, and that would be the debt side of that equation, is figuring out how much risk is involved with that equity ratio, right?
Not necessarily. I mean, sure, some folks look at debt, and if they feel that a company has too much debt, that they may be more risky, but that is, there's, again, a myriad of factors that could lead to your risk.
Okay. I appreciate you schooling me a little bit on this. I'm not an economist. I'm a lawyer, so my math is always a little off. But after several days of just listening to folks talk about ROEs and all these different equity ratios, the only conclusion I can come up with is that there's a lot of different ways to come up with an ROE. Is that correct?
Yes, that's fair to say.
Okay. In fact, there's so many ways to calculate the ROE that the commission here hasn't blessed any one or two ways. They're pretty much open to any way of calculating this ROE, correct?
Yes, so, as I cited in my testimony, the commission has previously stated they don't, preclude necessarily any models or have chosen any one or two, but they have noted certain models that they disagree with or have given little weight in the past.
Okay. So by having said that, you'd also agree that they've not rejected any kind of methodology, have they?
Well, I guess, I'm obviously not an attorney how you would determine reject, but I would argue if they state that, for example, the ECAP-M is given little weight, I would argue that that is a rejection. And they have rejected non-utility-based models as well.
Well, if we can turn to your direct testimony on page 9.
Sure.
Lines 7 and 10. And if you don't mind, would you mind reading lines 7 through 10?
Sure. So let's see. So it says, neither will the commission eliminate any particular methodology as, a little too fast. Neither will the commission eliminate any particular methodology as unworthy of basing a decision. The subject is too far complex to reduce a single mathematical formula. However, the commission has rejected or given little weight to some methodologies, which I describe later on. For example, when I refer to witness Diascendis's ECAP-M, if I could just find that real quick. The commission has stated that they give it little weight. So, for example, let's see. On page 37 of my direct, let's see, on line 20, I said, however, the commission has stated that it finds, quote, finds that the ECAP-M result should be given little weight because the ECAP-M is not widely accepted by financial community in determining ROEs. I go on to describe that FERC has also rejected it. So again, like I said, the commission has kind of stated they haven't chosen any one model, but they have given opinions on other models. That
Giving something little weight is not a full-out rejection, correct?
Again, I'm not an attorney, but I would imagine if someone's giving something little weight, they're not considering it in their decision. So to me, that really is a rejection.
Well,
they're not rejecting that a witness can't provide it, but they have stated that they're really not going to consider it.
But it's not an outright rejection. It's just we'll consider it. We'll just give it little weight, but we'll still consider it as part of the equation. It's not an outright no. It's off the table.
Sorry to interrupt. No, I would frankly disagree with it because I think the commission is saying they will not give it any really consideration. If they're saying they're giving it little weight, to me that means you're not considering it.
All right, we'll move on a little bit. We'll change gears on your comments regarding a calm and stable economy.
Okay.
You talk quite a bit about the volatility index, right?
Mm-hmm.
And you make a really good point about March 2020 having an incredibly high VIX. We'll call it VIX, right?
Yeah. Yep.
It had a spike that went up to almost 83% on that VIX, right? It's been dropping since then, but we know that we had a black swan event of COVID-19 in March 2020, which is pretty significant.
Sure.
Okay. But wouldn't you say the average VIX pre-March 2020 is lower than the post-March 2020 base? If you were to take a look at that graph for, say, the last 10 years, the last 20 years, you could see that the floor of the VIX is actually elevated in the post-March 2020 economic environment, would you say?
No, I can't say that. I haven't seen that data. In my opinion, usually the VIX is in like the low teen area, which is where it is right now. So no, I haven't seen that, and I can't state that.
Historically speaking, though, isn't the VIX normally under 20%, or considered in the 20% range, pretty high? Anything below 10% would be considered low. So that that low area would be low teens, I guess, 10, 11, 12, possibly 13 would be normal range?
That's hard to say. In my opinion, I would say below 20 is kind of low, kind of normal range, and that's frankly where we are right now. But there isn't really a hard and fast rule, I would say, on the VIX.
So in your same direct testimony, you mentioned that the Federal Reserve will no longer increase interest rates. Is that correct?
No. I say that it's a possibility that they'll no longer increase rates.
Okay, and you were basing this on the May 3rd meeting that happened this year with the FOMC, correct?
Largely, yeah.
All right, we know this because you had a dot plot in your testimony that you included, but that has since been revised by the FOMC. Is that right?
Yes, that's correct.
Which way was it revised?
I guess could you? I don't exactly know what you mean by that. Which way
Was it revised? Was that dot plot revised up, or was it revised down?
Well, it depends where you're looking.
Well, interest rates can only go up or down, right?
Well, no. So there's multiple years included on the dot plot.
Right, that's true.
So
But let's talk about 2023, 2024.
Sure. So I believe it went up slightly. But again, this is just kind of their thoughts at the time. As you may know, inflation was 3% for June 2023, which was the lowest reading, I believe, since March 2022, and it's decreased 12 months in a row. So, at their next meeting, it may be revised again.
Right.
But yes,
despite that inflation being low,
Mhm.
the FOMC has still committed itself to an era of quantitative tightening. Is that correct?
yes, yeah.
Okay. So quantitative tightening, can you explain what that is for us?
Well, so kind of during COVID, there was quantitative easing. So the
Can
federal
you explain to us what quantitative easing is?
Sure, generally. So they were really just purchasing bonds, mortgages, things like that to keep rates low, and now they're no longer doing that, and they're not replenishing the balance sheet. So when things roll off, they're not purchasing it again. They're just kind of letting it roll off.
Okay. So for a layperson like me,
Mhm.
when I hear quantitative easing, does that basically mean banks are going to have less money supplied to lend out? In layman's terms.
It's hard to say. I think it would really. I believe they increased the money supply.
They've decreased the money supply. Right?
Recently, they've decreased it. Yeah, they
Right.
increased it with the quantitative easing. Yeah.
Wait, they've gone back into quantitative easing here?
No. I believe with the quantitative tightening, they've lessened the money supply.
Correct. Yeah, quantitative easing is
Yeah.
increasing the money supply. So
Yeah, I
there's-
think you excellently said. Sorry.
Yes,
Yeah.
ma'am.
Sorry, I think you misspoke. That's why I was just trying to clarify.
Yeah. Quantitative. Well, then, let me correct myself. Quantitative easing is increasing the money supply
Yes.
by injecting that money into the bank so that they have more lending, which is why we had lower interest rates, basically free money, right? People can borrow at incredibly low interest rates. Quantitative tightening, if I understand correctly, is reducing the money supply, which means interest rates go up higher, which hopefully encourages people to save more money, right, because they get a better interest rate. But it also makes borrowing a bit more expensive, doesn't it?
Yes, I can generally agree with that, but the quantitative tightening doesn't necessarily in and of itself increase interest rates. There are obviously other factors that influence.
But it's certainly a factor that. Yes.
I think that was it. I said it's one factor that influences interest rates, the quantitative tightening. It's not the only factor.
Okay, so back to the question I was going to ask is, it makes borrowing a bit more expensive for those that are looking to borrow money from the banks.
It could.
It could. I mean, if there's less supply, I mean, if we're just looking at a standard supply demand chart, right, from Econ 101, less supply is going to increase that. It's going to move that.
Well, again,
price
there
over.
are other factors. Sorry to interrupt again. So, for example, the federal funds has increased their rate to 5 to 5.25. However, 30-year Treasury yields are trading at a lower rate. So the Fed may try to do certain things, but that doesn't mean they will occur. But there's a myriad of factors that influence interest rates, such as investors, expectations and what they're looking for.
Would another factor be the recent stressors on the banking system that have happened? I guess in the last 4 months, we've had some serious stress tests. would that affect the cost of debt?
It could. So I believe there was a kind of slight spike in just say Treasury yields when that occurred, and they've actually come down since then, since inflation's been easing, and there really hasn't been any banking issues since then. Some folks think that is kind of a one-off event. I believe there's 2 banks, but that there was really their poor business practices that led to that.
Okay.
They got a bit aggressive and weren't kind of covering a lot of the bonds that they were purchasing.
So would you say right now our economy is experiencing a relatively stable, calm era? Interest rates are down to what? Are down fairly, or inflation's down to 3%, you
Sure.
said, right? Interest rates have gone up, but right now you think we're at a pretty good, stable place?
Generally, yeah. I mean, I believe it was Walmart's cross of Mr. D'Ascendis on Tuesday that, is it ever calm? And, folks seem to always have some issue. But, yeah, in my opinion, it is frankly pretty calm right now. All the 3 major market indices are up. The VIX is down. Frankly, if you haven't been invested in the last 6 months, you've missed out on a lot of gains. So, yeah, I would say it's calm. And, folks are saying, well, interest rates are out of control or inflation was out of control. But that's just frankly not the case. Inflation has peaked. Like I said, it's been down for 12 straight months. And interest rates have been actually pretty calm recently. The 10-year and 30-year have been hovering right around 3.8%. And it's been, I would say it's been pretty calm.
So if you're an investor, you're feeling fairly confident?
Yeah, if you've been invested. If you
Yeah.
haven't, you kind of have FOMO right now.
Right.
Mm-hmm.
FOMO is fear of missing out, if you need to put that in the record there. So as far as we're, I guess to paint that picture, we're living in a good, stable economy. Things are going well. Investors, hopefully they know what they're doing. They see the conditions out there, economically speaking, that is. Are they going to want a higher return on that investment, or are they going to want a lower? Is that going to put any kind of downward pressure on ROEs?
Yeah, again, it depends. There's a lot of factors. Obviously, we conduct models to determine our ROEs. So I would just really have to lean on that. I mean, you can't say just if a market's down, they need a higher ROE. If the market's low, they need a higher ROE. I mean, you have to kind of run the models and use all the variables to determine that.
Okay, it's not. So I really just want a plain answer. Is right now encouraging us as an investor, or me as an investor, would I want to look for a higher ROE, or would I feel comfortable asking for a higher ROE?
Again, that's why you kind of have to do the analysis to determine whether it's comfortable or not. Obviously, an investor would always want a higher ROE. Everybody would always want a higher return. It's whether that is an appropriate return is the question.
Okay. Well, I'll move on. I'll let that one go. The next thing I wanted to talk about, and this is, again, I'm not an economist, my apologies, and I do have a little bit of FOMO because I did not jump in the stock market right away. But as far as recession goes, that was one of the comments you also made.
Sure.
Is that we're facing economic headwinds. We have an inverted yield curve, right? Yield curve. So those same investors that right now see a stable and calm economy, are they also seeing calamity at the door?
Well, I wouldn't say they're seeing calamity. That's a bit aggressive.
Well, what would a recession be other than?
Well, there's obviously recessions can be small and large.
Are we
we're hearing of the soft landing, so to speak, where we may not even have a recession. So no, I believe witness D'Ascendis tried to also characterize that. I said there will be a recession. I was simply stating that there's some folks that think it's possible. However, markets are still stable even with them thinking that this is a possibility. I simply just provided that to note that interest rates possibly may not increase as much, and the markets are calm and stable even with folks having this opinion.
What resources did you look at to make that statement that a recession could be coming?
I cited the Federal Reserve itself. Let me find that for you.
By the Federal Reserve, do you mean the SAM index?
No. So the FOMC.
Meeting
There's
minutes?
Their summary of economic projections. So I cite 13 on page 13. So yes, I'm trying to find the number. Yes, but yeah, in the Federal Reserve statement, they did state that they felt it was a possibility of a recession. I've also cited other sources who were indicating that's a possible recession.
Okay. You didn't quote Jim Cramer, though, right? It's usually the opposite of what he says.
I did not quote Jim
All
Cramer.
right.
No.
So you went to business school. You studied this your entire career. Are you familiar with the SAM rule? SAHM rule.
I don't believe so.
Okay. Your Honor, if I may approach. All right.
Thank you.
I was not going to offer this. I was just going to use it as a reference. All right. Well, if I don't do anything right today, I at least made enough copies for everybody. This is good. All right. What you have in front of you here is it's called the Real-Time SOM Rule Recession Indicator, and this is actually put out by the St. Louis Fed. Does the St. Louis Fed have any credibility when it comes to discussing, I guess, the economic environment? Are they part of the FOMC?
Well, I'm not sure if they have. I would imagine they have a member on the FOMC.
They do. They do have a member on that.
Mm-hmm.
So that means they would have a voice, right?
One voice.
One voice, right?
Mhm.
They're part of that discussion.
Sure.
They're part of that analysis. So the SOM rule is, if you can read, I should have marked this for you, but if you go down into the notes, where it says frequency, it's a monthly frequency. There's a sentence there. If you could just read that for us, and that'll help define for everybody what the SOM recession indicator really does.
Which sentence was that?
It's way down at the bottom, and my apologies for the small font, but it's right underneath where it says frequency. If you go down to the notes at the mid-page,
Sure.
just under that middle hole.
Sure. So it says SOM recession indicator signals the start of a recession when the 3-month moving average of the national unemployment rate rises by 0.50 percentage points or more relative to its low during the previous 12 months.
Okay.
Yeah.
Okay, so if you're looking at that graph, and I printed this graph out just this week.
Mm-hmm.
If you take a look at that graph, where is that graph relative to what it shows in 2020? Would you say that the line is close to zero?
In this graph, yes, it is close to zero. Now, I'm not familiar with the SAM rule and whether it's even accurate, but yes, as of right now, this says that it seems to indicate a low chance of recession.
So would you say, subject to check the credibility of the St. Louis Fed, is this graph correct? Or would you agree with this graph?
Well, I guess I wouldn't agree with that statement, subject to the St. Louis Federal Reserve's credibility. Now, they may produce this, but they may not use it in any way to inform their decisions.
Do you think something like the St. Louis Fed would actually publish something and not actually use it or give it any weight?
Sure, there's a myriad of models out there, economic models to determine everything in the financial world. I mean, anyone would tell you all the macroeconomics that have ever, macroeconomic models that have ever been produced have never accurately predicted every recession or every boom economy that's ever happened.
Right, but if I were to put out a website and a blog with my own economic predictors,
Sure.
would you give that more weight or equal amount of weight as you would the St. Louis Fed?
Again, I have no knowledge of if this has ever even been accurate, so I can't. So no, I can't speak to that.
Okay, that's fair. All right. Let's see. All right. So as far as the discussion regarding recession, would you say that your comments regarding recession is purely hypothetical? It's a big what if. We don't really know if we're going to enter a recession or not. Sure, there's indicators out there that may indicate so, and there's also indicators that indicate we might not. Is that correct?
Sure. So my position was not hypothetical. It was based on investor opinions, the Federal Reserve's opinion, which is what the ROE is supposed to be based on, investor expectations. So I was taking the expectations of investors and the Federal Reserve to determine my recommendation, my opinion.
Expectations don't necessarily make something true, though, do they?
Expectations, no, they don't always come true. But again, the whole point of ROE is to determine investor expectations. So if they're expecting a recession, that is more important than if it happens or not, frankly, at this point in time. It's what they're expecting to occur.
But if it doesn't occur, then what's that expectation worth?
Well, that's all we have to judge on right now. I mean, I don't know the future. I don't have a crystal ball, but you have to use investor expectations. That's the whole point of an ROE.
But an expectation does not make something imminent.
It does not make something imminent? No, not necessarily. But as Whitner's D'Ascendis was saying on Tuesday, you do the ROE today. Okay. So I only have expectations to base it on. I don't, again, have a crystal ball, so I can't tell you what's going to happen.
So
I can't tell you what's going to happen.
I just have one final question.
Sure.
A comment you made in your testimony is that there is downward pressure on the cost of equity as a result of this expectation of recession.
There could be, yes, correct.
There could be.
Yeah.
But as the way things stand today, that's not the case.
What's not the case?
The downward pressure on the ROE.
Well, not necessarily. Like, again, you have to run the models to determine that. And frankly, my models are usually very consistent. And as I discussed with the equity risk premium as well, it's very consistent. So folks may want to say, oh, well, it's a down market, it's up market, the equity risk premium is, has gotten large, it's gotten small, but it's usually very consistent. Okay. So my models have consistently produced numbers kind of in the low to mid nines. So, I just have to go on what my models say. I'm not trying to influence them in any way. They produce what they produce.
Okay. Well, thank you, Mr. McAuliffe. That's all the questions I had for you.
Sure.
Any redirect?
No, I don't believe so, Your Honor. Thank you.
So you're the director of your division here at the commission. Fair to say you've been the ROE witness several times before.
Yes.
Okay.
Many times.
Would it be fair to say that for the last couple of cases that you've testified in, you've changed it up a bit?
So from the last case I filed, no, it is not.
The last couple of cases?
So I guess if you're referring to the equity risk premium?
Yes.
Yeah, so witness D'Ascendis classified it as my new method. Sure. Witness D'Ascendis classified my equity risk premium as a new method, but that's not accurate. I did it in the case 9681, Delmarva's multi-year plan.
So it's a new approach in the last couple of cases that you've...
Sure, and I use the same method in the current BG MYP. You can find that testimony as well.
So I'm going to get to the question of why'd you change it up.
Sure.
But prior to changing up your approach, it's fair to say that you start with the same approach and that you're trying to be consistent in your approach to different utilities, even though the facts change in each case. Correct?
Sure. I mean, obviously you want to generally be consistent. You want to be changing things, every case kind of willy-nilly, but, I also don't think it's appropriate for you to be conducting the same methods for 20 years. I would imagine you've, acquired some learnings and, developed some new things over the course of time.
Absolutely. So prior to changing it up,
Mm-hmm.
did you start with your regular analysis and then make a discovery or an assumption that changed your perspective?
That's a good question. I believe, because it's something because I did point out in my testimony, full transparency, that this was something generally new that I was doing. I didn't hide that fact.
Yes.
But so as when I discussed it in my direct, if I can find the page.
So I'm going to ask that you not turn to, you can give me the page
sure.
reference.
Sure.
I'm going to ask that you not turn to direct. I love live testimony because sometimes you get it the way you explain it to your grandma, and it makes it great for my orders.
That's no problem. But yes, no, I was just going to say that, as I discussed in my direct, I had some issues with the equity risk premium in previous cases. It was just in my opinion, it was getting a little, far from where I thought it seemed to be based on just historical data and other things. So, for example, my previous method, it was just the historic market return subtracted by the risk-free rate. Well, and as witness Descendis pointed out on Tuesday, when you're kind of just tie it to that, it can get out of whack. So, for example, when interest rates were like 1%, you're getting equity risk premium of 11, which is in history just really doesn't make sense. And if you had high interest rates, let's just say 9%, you'd only get a 3% equity risk premium. It just wasn't consistent enough, in my opinion. So that's why I switched to using the historical equity risk premium, which SBBI, the Kroll book that witness Descendis himself even cites, said is fairly stable throughout time. So I felt that was a more consistent method, and because the CAPM, frankly, is can easily be subject to fluctuations because there's only a couple variables. So I felt that was the better method, because that way you have that historical equity risk premium, but then you're tying it to what the current and or projected risk-free rate is. So I just felt it was more appropriate and frankly more accurate. And I know witness Descendis provided that table in his surrebuttal to kind of refute that. And I do have some major concerns with that. First of all, is that the equity risk premium published by...
Hold on, stop for a second. Are you referring to the table on page 26 of witness Descendis?
Yes, the one you
Descendis'
asked him
rebuttal?
about, if I remember correctly, on Tuesday. Yes. So, it's page 26?
Yes, 26 of the rebuttal.
Correct. Yeah, so...
That's what I was going to ask you about next.
Oh, great. I came prepared. So the problem is he's comparing the equity risk premium produced by Kroll, also known as used to be known as Duft and Phelps, and Demoterin against the market returns of the S&P 500. So the S&P 500 is only 500 stocks, but the equity risk premium, for example, of Kroll, it says the United States equity risk premium. So I wouldn't, you shouldn't just use just one market indice for the United States as a whole. So what he's doing in Table 3 here, he's simply summing these percentages and then dividing them by this observed market return to say which is off or correct. So I believe with his observed market return, you get around 190%. But if you were to use the New York Stock Exchange returns, it comes out to about 110%. He doesn't have the sum here. It would be in that forecast bias where he has this blank hole under observed market return. I believe it was about 190%, subject to check. But if you use the New York Stock Exchange, it's 110. And the most accurate, using his same method, is actually Demoterin, because he's the lowest. And because his sums to about 107%. And it works its way up. So then the long average return is the least accurate if you use the New York Stock Exchange composite changes per year.
I'm not following that distinction. Can you explain it?
Sure.
Grandma?
So he's using...
Trouble hearing Mr. McCullough
Oh, I'm
when
sorry.
he turns away
Sure.
from the
So I
microphone.
think
Apologies.
you're facing the chart, so can you
Turn
turn the
it.
mic?
Sure. No problem.
Thank you. I'm sorry.
My apologies, Your Honor, but what page?
26 of
Is that
the
26 of the
Descendis'
cerebral?
rebuttal.
Yes, ma'am. Thank you.
Just wait a second while counsel
Sure.
gets there.
My apologies. Thank you.
No problem.
So you mentioned Demoterin
Demoterin, yeah.
and Kroll in your testimony. I think that's why this is included in the chart.
Correct.
Do you think
I believe so.
Demoterin and Kroll are reliable?
Yeah, yes. I mean, they're well cited, well referenced in the investment community. Frankly, most people use Kroll's data. It's hard to say the number, but most ROE analysts you see will use their information. And Demoterin is one of the most famous, financial minds out there.
So now you were trying to make a distinction.
Yes.
You didn't address this chart in your rebuttal.
Unfortunately, I did not.
Okay. you were trying to make a statement using a different input and how that would impact the forecast bias
Yes.
row across the bottom. Can you start over and
Sure.
do that slowly?
Yes, ma'am. So you can't tell by looking at this chart, but so observed market return is the S&P 500
Right.
return. So as I was explaining, Kroll and Damodaran, they don't produce an equity risk premium for the S&P 500. They produce it for the United States equities. So in the S&P 500, there's only 500 companies. For example, Tesla wasn't included until just last year. Uber's not included. There's large companies that aren't included in the S&P 500. If you use the New York Stock Exchange composite, which is what we use to measure beta, it includes all the stocks, in the New York Stock Exchange, which is thousands. So, in my opinion, that is a better indicator of the equity risk premium for the United States as a whole. So, if you use the market returns of the New York Stock Exchange on a year-by-year basis, Damodaran actually becomes the most accurate. Kroll is the second most accurate. The long-term average, third most, etc. So it's literally the exact opposite of what this chart has.
And have you done that analysis?
I have. Unfortunately, like I said, it was after Sir Rebuttal was filed. Unfortunately, you can only do it with his work papers. You can't. Looking at this table, it's hard to understand.
Okay. Thank you. I appreciate your time on this issue. I know it's a small issue and it doesn't, really weigh into your overall recommendations, but I appreciate the clarification.
Sure.
Just give me one moment. I don't have any further questions. Counsel for staff, do you have any questions based on mine?
No, I don't have any questions.
Thank you for your time.
Thank you.
Would this be a good time for like a 5-minute break?
It'd be a perfect time. Thank you for asking. We can go off the record. we can go back on the record. Staff, do you want to call your next witness?
Yes, Your Honor. Staff calls Anson Justy.
Can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth?
Yes.
Can you state your first and last name and spell it for the court reporter?
My name is Anson Justy, ANSON JUSTI.
Your witness.
Thank you, Your Honor. Mr. Justy, please state your current employer, title, and business address for the record.
I'm employed by the Maryland Public Service Commission. I'm a regulatory economist in the electricity division, and my business address is 6 St. Paul Street, Baltimore, Maryland, 21202.
Thank you. And do you have before you a document titled The Direct Testimony and Exhibits of Anson Justy, filed on behalf of the Maryland Public Service Commission in case number 9695 on June 9th, 2023, comprised of 38 pages of narrative testimony and 3 exhibits?
Yes.
And was this document produced by you or under your supervision?
Yes.
And do you have any corrections to make to this document?
No.
And if you were asked the same questions contained in this pre-filed testimony today, would your answers remain the same?
Yes.
Thank you, Your Honor. I would like to have this marked as Staff Exhibit 5.
Staff Exhibit 5 is marked.
Thank you. Now, Mr. Justy, did you file or cause to be filed an errata to your direct testimony on June 21st, 2023, with clean and red line edits to your direct testimony and 2 additional exhibits?
I have the date as June 16th, but I did file an errata.
Okay. I believe it was filed on June 21st for the record, Your Honor.
Okay.
Your Honor, I would like to have the errata marked as Staff Exhibit 6.
Staff Exhibit 6 is marked.
Thank you. And Mr. Justy, do you have before you a document titled The Surrebuttal Testimony and Exhibits of Anson Justy, filed on behalf of Maryland Public Service Commission in case number 9695 on July 14th, 2023, comprised of 17 pages of narrative testimony and 1 exhibit?
Yes.
And was this document produced by you or under your supervision?
Yes.
And do you have any corrections to make to this document?
Nope.
If you were asked the same questions contained in this pre-filed testimony today, would your answers remain the same?
Yes.
Thank you, Your Honor. Could this be marked as Staff Exhibit 7, the surrebuttal testimony?
Staff Exhibit 7 is marked. Counsel, you were correct. The errata was filed on June 21st.
Oh, thank you. Mr. Justy, do you adopt your errata, and your surrebuttal pre-filed testimony as your testimony in this case today?
Yes.
Your Honor, I would request to have Staff Exhibits 5 through 7 moved into the evidentiary record.
Any objection? Staff Exhibits 5 through 7 are admitted.
Thank you, Your Honor. Mr. Justy is available for cross-examination.
Walmart?
Yes, Your Honor. Actually, I do have some cross for this witness, but I hope we'll be done by 8 this evening. Mr. Justy, good morning. My name is Barry Naum. I represent Walmart in this proceeding.
Good morning.
Could you please turn to your direct testimony?
Are you in the errata version, Mr. Naum?
You know, Your Honor, I confess I do not have the errata. I don't believe that this would address any of the corrections that he had in the errata, so I am in Exhibit 5.
Okay, thank you.
Mm-hmm.
I'm there.
Okay, Mr. Justy, on page 4 of Exhibit 5, your direct testimony.
So I think this is titled the 4-step method of revenue allocation in the top left corner.
My version just begins with the question, what are the principles of rate design?
Oh, page 4 of the narrative.
Wait, I'm sorry, page 4 of Mr. Justy's direct?
Yes, Your Honor. Do I have the same page?
Okay, my pagination is different, so tell me again what.
Okay, so
is there a
it must be
header or a
because
question?
I just wanted to ask him a few questions in his direct, and again, I'm going off of what appears to be Exhibit 5.
Okay,
I don't believe this is the errata. This is the exhibit filed on June 9th, 2023.
so no worries. Is there a question or a header on the page you're looking at?
There is, the only header that I have on my version, Your Honor, is the case number, direct testimony of Anson R. Justy, and then it's got a question that states, what are the principles of rate design?
Okay, I'll get to that question. Go ahead with your question.
If I may, Your Honor, my version has that question starting on page 3 of
Thanks.
his narrative testimony.
Yeah, I just found it.
Okay, thank you, counsel. I confess that I don't quite understand why my version is different, but Mr. Justy, if you could take a look at that Q&A that starts, what are the principles of rate design? Do you see where we are?
Yes.
Okay. In that Q&A, you state that the principles of rate design in general, and I'm going to quote you, incentivizing customer rationing, avoiding rate shock, yielding the revenue requirement, and ensuring fair cost apportionment. Is that a correct statement of your testimony?
I think I used the word consumer rather than customer, but yes.
Oh, I'm sorry. You did. Consumer. Thank you. Then if we go to, if we go two questions past that, I have a question that states, what is rate shock and what is gradualism? Do you
So
see
we're looking at page 5.
page 5? Okay. Yes, and that's page 5 on mine as well. Thank you, Your Honor. Do you see that Q&A?
Yes.
As you're discussing gradualism, you state on line, well, in your second sentence, or third sentence, I'm sorry, you state, this principle can sometimes conflict with other principles such as fair cost apportionment. Is that accurate?
Yes.
And you summarize that conflict as stating where setting the rates such that a customer class is charged commensurately with the cost of serving that class would result in a very large change in customer bills compared to the previous bill. Is that a correct statement of your testimony there?
So the point I'm trying to make is if setting rates such that a customer class is charged commensurately with the cost of serving that class would result in a very large change in customer bills, that would conflict with gradualism.
Thank you. So that is when, in your opinion, gradualism would then take effect, correct?
I don't think there's necessarily a defined point at which time gradualism takes effect, but it is a consideration.
But again, generally speaking, if assigning costs based on, or I'm sorry, if setting rates based on the cost of serving that class would result in a very large change, then it's your testimony that gradualism would mitigate against that. Is that fair?
I think that's fair.
Okay. Thank you. If we could then, Mr. Justy, go to the discussion that you have in the next Q&A regarding fair cost apportionment. On my version, it starts on page 5, and then the major discussion is on page 6.
If I may briefly, if you could maybe just lean into your mic a little bit. We were having some trouble hearing you. Thank you. Sorry,
Is the light on your mic?
The light is on, yeah.
You see that Q&A?
Yeah, I'm there.
And at the first sentence in your answer to that question, you state that fair cost apportionment refers to the principle of cost causation, correct?
Yes.
And could you just briefly state, so that I'm not reading your testimony, what's your understanding of the principle of cost causation?
So in general, one goal of rate design is to set rates such that the cost of providing service meets the cause causing that cost of providing service, or the price returns revenue that meets that cost.
So to summarize, is it fair to say that the rate charged to the customer should reflect the cost that that customer causes to the system?
That's one goal, yeah.
Okay. Can I just look at your testimony? Yeah. I just want to make sure that I'm directing him to the correct line. Okay, if you could turn Mr. Justy to line 8 on page 6. Thank you.
Okay.
You state where and I'm going up a little bit, a few lines, but where a class provides revenue less than its costs, you state, beginning on line 8, that the class providing more revenue than its cost is said to be subsidizing the other class. Do you see that?
Yes.
And if I understand this discussion, what you're talking about is what I would refer to as interclass subsidization. Is that an accurate assessment?
Yep.
Subsidization between two separate rate classes. But then in the next paragraph, you begin a discussion that indicates that within a customer class, these principles also apply. Is that a fair summation of cost causation principles?
Yeah, just like with gradualism and policy considerations, and that is one of the considerations.
So you would agree with me, Mr. Justy, that subsidies can also occur within a specific rate class?
Yeah, I think that's fair.
And I would refer to those as intra-class subsidies. Is that a term that you're familiar with?
Okay.
It is?
It is.
Okay. Were you in the hearing or watching the hearing on Tuesday when Potomac Edison's witness Fall testified?
I was there.
And do you recall Ms. Fall agreeing with me that an intra-class subsidy may create a risk to just and reasonable rates?
I do remember that. I don't necessarily agree that in this case there's a risk to just and reasonable rates. So my proposal on the demand and energy charge, which I think is what we're going to, is to maintain the current ratio between demand and energy charges. That current ratio was approved by the Commission in the prior case, and when the Commission approves rates, they determine that they're just and reasonable.
If you don't mind, I would just like if you could answer my original question, whether you acknowledge that Ms. Fall testified that intra-class subsidies may cause a risk to just and reasonable rates.
She did testify that.
Okay, thank you. Okay, thank you, Mr. Justy. I think at this point we can avoid some of the administrative troubles that I have with your direct, and we can move to your rebuttal testimony. And this would be Staff Exhibit 7. And I am looking at page 11 of Exhibit 7.
Okay.
And you anticipated well where we were going with this, and this is in discussion to Walmart witness Cronauer's proposal to make a slight modification to Schedule PH, which was ultimately supported in rebuttal by Potomac Edison. Is that correct?
Yes.
Now, just for clarification, you did not file rebuttal testimony, correct?
No.
Mr. Cronauer proposed this rate design modification in his direct. Is that accurate?
Yes.
Can you help me understand why you did not file rebuttal testimony to Mr. Cronauer's proposal?
I didn't see a need to respond until witness Fall in rebuttal testimony brought up witness Cronauer's rate design proposition.
But you acknowledge that Mr. Cronauer raised the issue first, correct?
Yeah.
Mr. Justy, can you move your mic closer to your
Yes.
You can just pull it towards you.
And your sir rebuttal testimony was filed last Friday, July 14th. Is that accurate?
Yes.
A weekend before the hearing started, correct?
Yep.
Thank you. Now, loosely stated, would you agree with me that Walmart's proposal is to reduce the Schedule PH energy rates and recover more of the PH class costs through the demand charge?
I think that's accurate, subject to check.
And subject to check, assuming that you are familiar with Mr. Cronauer's testimony, would you agree that his proposal would take effect only if the Commission awards a lower overall revenue requirement than Potomac Edison has requested?
Yep.
Okay. And would you agree that Mr. Cronauer's proposal here is based upon the class cost of service study developed by Potomac Edison Witness Lyons that shows 86% of Schedule PH costs are demand related, but only 52% of those costs are collected through the demand charge?
I would have to check the numbers. I would note that the staff has raised questions on whether the cost of service study is entirely accurate, and that cost of service study is generally used as a guide for rate design.
Do you have any reason to dispute that that Mr. Lyons' analysis of the 86% of demand-related costs versus the 52% of costs collected through the demand charge is inaccurate?
So I didn't analyze the cost of service study.
Okay. But based on, and I'm again looking at your sir rebuttal testimony, based on your testimony, you did analyze Walmart's proposed rate modification and developed a couple of exhibits, or I'm sorry, one exhibit, Exhibit ARJ-6, is that correct?
Yes.
And ARJ-6 and the findings therein are summarized on page 12 of your sir rebuttal testimony in tables 3 and 4, correct?
Yep.
And just for clarity for the record, tables 3 and 4 and Exhibit ARJ-6 were developed using staff's recommended revenue requirement and not Potomac Edison's, correct?
That's correct.
And staff's recommended revenue requirement is lower than Potomac Edison's as filed position, correct?
That's correct.
So using staff's revenue requirement, if the commission were to adopt Walmart's proposal, this would be a situation that Mr. Cronauer proposes it being applied to, correct?
I believe so.
And I apologize, that was a compound question, but I believe you understood it. If we look at page 12 of your sir rebuttal testimony at lines 3 through 7, you state that under Mr. Cronauer's proposal, the average monthly distribution bill impacts change minimally when all else is held constant in the rate design. Is that accurate?
That is accurate. I then go on to say that for not the average customer, within the class, there are winners and losers here.
Great, and we're going to talk about that because specifically you state that low load factor customers could see between a 3 and 4% change, and high load factor customers could see between a 2 and 5% change. Is that correct?
I do state that. I would also note that my analysis, based on the work papers from PE, looked at load factors between 40 and 100% or so. So a later DR that came back too late to file sir rebuttal has data on the range of load factors within PE's service territory. And that has ranges of load factor ranges between 0 and 1,030% for class PH and between 17 and 87% for class PP.
Okay. Does that change your analysis that Walmart's proposal would result in a minimal bill impact?
For the average customer, I would not change.
You would not, okay.
I would note that the magnitude of the effects on the winners and losers would grow, though, with this increased range of load factors.
Well, so I'm glad that you mentioned winners and losers, because you do reference creating winners and losers on page 13, and that's, I believe, no, I'm, pardon me. Yes, it's on line 4 of page 13, where you mentioned that this proposal would create winners and losers. On Tuesday, Potomac Edison witness Fall testified that intra-class subsidies currently do exist within the PH rate class. Assuming Mrs. Fall's testimony is correct, isn't it true that large load factor customers have been losers on the schedule PH for many years?
Assuming the cost of service hasn't changed over many years, assuming the customer population hasn't changed over the years, assuming the use pattern of that customer population hasn't changed over the years, then I think that's fair to say.
Are you a country music fan?
Not particularly. I can appreciate it on a sunny day, though.
As I was preparing my cross, all I could think of was a 90s country music song called A Better Class of Losers, and that's all I could think of. So essentially what Walmart is proposing is to create a better class of losers. Is that correct?
I'm afraid to operate inside of an analogy
That's
here.
fine. That's fine. It was unfair. If we move to page 14 of your testimony, Mr. Justy, you state your ultimate conclusion is that you do not recommend adoption of Walmart's proposal in this case, correct?
That's correct.
But I believe your testimony indicates that it is an option that the Commission could consider.
I think it's an option the Commission could consider. I would want to run, based on the results from that DR 29, I would want to run further analysis than is included in my SIR rebuttal before going forward, but I think it's something the Commission could consider.
Okay. And the basis for your recommendation, which is that the Commission not adopt this proposal, is twofold. And this, again, is on page 14. Your first reasoning is that, and I'm stating this on, it's from line 5, you state that Walmart represents only one commercial customer that PE serves, so it cannot be said that Walmart's interests accurately represent the whole population of commercial customers. In this case, to your knowledge, Mr. Justy, Walmart has not suggested that it represents all commercial customers, has it?
No.
Are you aware of any single commercial customer in the PH class that would accurately represent all customers in the class?
I don't think so.
You did read Mr. Cronauer's testimony?
I did.
And you would also acknowledge that Walmart has 12 facilities in the Potomac Edison service territory?
Subject to check, yeah.
So it is one customer, but with 12 different facilities?
Yeah.
And are you familiar with Walmart Exhibit 2, which was a stipulated DR response to staff submitted into evidence yesterday?
No, if it was submitted yesterday, no.
Oh, okay. And I apologize, I gave Your Honor my only copy.
Thank you.
Well, she just gave. I just have one brief acknowledgement on there. Would you acknowledge that Mr. Cronauer, in providing his response to that directed answer, I believe it'd be on page 1 of that exhibit, indicates a range of load factors for Walmart?
Yeah, I would say that's a range.
Yes, but at the same time, Walmart does acknowledge that it is a high load factor customer, at least in its estimation.
Yeah.
You state I'll strike that. Is there anything to your knowledge that would have prevented a low load factor customer from intervening and becoming a party to this case?
Not to my knowledge, no, but I'm not particularly familiar with the legal procedures.
Okay. Because it seems to me that you're suggesting in testimony that Walmart's position should be rejected because it happens to be a party in the case. That's not what you're saying, is it?
No, I don't think that's a fair categorization. I think the staff's purpose here is to consider all of the commercial customers, all of the potential stakeholders in a rate case. So I'm considering the Walmart position as an intervener, but for all the other stakeholders who can't intervene, I do have to consider their welfare.
Would you need to see the load patterns of every customer in the class in order to support a recommended rate change?
Not everyone, but I would need a better range than was available in the PE work papers.
But you don't think there's fundamentally an issue with a party to a proceeding advocating for its own interests, do you?
No.
Thank you. Moving on, then, the second basis for your recommendation that the Commission not approve this change begins on line 13 of page 14. And you state that this proposal disproportionately impacts low load factor customers such as private electric vehicle charging infrastructure customers. To summarize, Mr. Justy, you believe that this proposal would disincentivize EV adoption within Maryland?
I think it could. So this goes to the point of consumer rationing that I raised in my direct testimony, where we don't want to incentivize customers from trying to game a higher load factor by wasting energy.
Okay, you say game and waste energy, but if a high load factor customer is also committed to energy efficiency, does that not also ultimately reduce their peak load?
It would if they didn't change their use pattern, but one could use energy efficient appliances or anything in pursuit of that and use electricity inefficiently, as in using it too often, even if it's used efficiently on a per unit basis.
Let's turn back to the EV adoption and EV charging infrastructure customers. Would it surprise you to know that Walmart has a corporate policy promoting EV charging at its facilities?
No, I don't think it would.
May I approach, Your Honor?
Yes. Thank you.
Yes.
I apologize to both Your Honor and to the witness and parties that in order to get this printed, I had to make a polite request to the receptionist at my hotel. And so this does not reflect what I would typically print for the purposes of this proceeding, but I would like to represent that this document is available at the following URL: corporate.walmart.com/newsroom/2023//06/ and for the sake of the court reporter, I would just note that what I'm about to read, there is a dash between every word. Leading the charge, Walmart announces plan to expand electric vehicle charging network. I'm not asking you, Mr. Justy, by any means to authenticate this document, but would you accept my representation that this is a press release issued by Walmart on April 6th, 2023, announcing its corporate goal for EV charging?
Well, I haven't looked at the link, and this doesn't say anything about that, so I'd be hesitant to do that.
You would. I understand. Okay, thank you. Your Honor, I would ask the indulgence of marking this document as Walmart Exhibit 3.
Walmart Exhibit 3 is marked.
Noting that you hesitate to accept that this document is what it reports to be, would you at least agree with me that in the first paragraph, last two sentences, this document states that Walmart by 2030 intends to build its own EV fast charging network at thousands of locations coast to coast?
Maybe not thousands, I see 1,000, but that is generally what it says.
Say that again. Sorry.
So I'm reading it as saying we intend to build our own EV fast charging network at thousands of Walmarts and Sam's Club's locations coast to coast, and that would be in addition to the almost 1,300 EV fast charging stations we already have available at more than 280. So I saw the 1,000.
Okay, I understand. Okay, thank you. Would it also surprise you, Mr. Justy, to know that Walmart has been actively investing in energy efficiency and demand response for the last 20 years or more?
I don't think that's surprising, no.
Okay. Your Honor, I believe that's all that I have for this witness, and I thank you for your time, Mr. Justy. I would move to have Walmart Exhibit 3 admitted into the record.
Any objection? Walmart Exhibit 3 is admitted, and I will go ahead and take judicial notice that I went to the website referred to by counsel, and it is a public news release from Walmart Corporation.
Thank you, Your Honor.
Office of People's Counsel, do you have any cross for this witness?
No, Your Honor.
Potomac Edison?
No cross, Your Honor.
Tell me a little more about DR 29.
So the question asked for, I believe, the minimum, maximum, and mean and median of the load factors within the commercial classes for Walmart, or for Potomac Edison. And I got a data set that had the load factors for many customers across many bills. So I looked at the range in preparation for this hearing.
Okay, and so then based off of staff's recommendation, what did you see?
In the DR or in my rebuttal recommendation?
Applying your rebuttal recommendation to the data in the DR.
So I make a statement somewhere about low load factors having an increase in their bills by a couple of percentage points. So the lowest load factor in that analysis was 40%. So if we have a load factor of 0%, that bill impact in percentage point terms would presumably increase potentially substantially. And then on the other range, the highest load factor was 100%, and there were some load factors in that data that were above 100%, one of them including at 1,000. Mathematically, I would like to follow up on how that exactly happens, but if we have a load factor of 1,000, that'll significantly reduce the bill impact if we apply the Walmart and PE proposal.
But you're not at this time. When did you receive that response?
It might have come in on Monday, but I'd have to check.
But you've not done the analysis based on...
No, it's a pretty big file, and there's just raw data in there.
Is it possible that the analysis, your position would change based on your analysis, having preliminary seen up to or over 1,000?
Yeah, I think it could. That's why I was trying to be conservative in recommending that the commission maintain the current ratio. And when I say I think it could change my recommendation, I think it would be more likely to be against it.
I'm sorry, what? You'd be more likely? What does that mean?
So I'd be concerned about what's happening to those 0% load factor customers. I'd be more concerned about that.
When was this DR posed to the company?
I'd have to ask from the company.
And was it a response to an earlier data response received from the company?
No, it was a data response that I sent during the surrebuttal period.
Right. Why did you send it during the surrebuttal period?
Because I wanted to look into that demand and energy proposal. When Witness Fall was proposing to, or agreeing with the proposal, and we started having multiple commercial customers being affected by this proposal, I wanted to do more analysis on that.
I'm sorry. All right, thank you. Anything else from staff?
Just to clarify the timing on that DR, Your Honor, that was served on the company on July 5th, and the company had a 7 business day response period in which they timely responded. But given the 7 business day response time, that was too late to incorporate any of that data into our SOAR rebuttal testimony. So just to clarify the timelines in regards to that specific DR.
Okay. Thank you for your testimony. You can be released. We're going to take a 10-minute break. We can go off the record.
Yeah. That less staff again, that evolved. Right. In our last case, Aaron was witness and other staff surveys. I've not seen, I have not seen at least half of the witnesses in this case.
Yeah.
But they, but you have to remember that there are multiple cases. So I think a lot of these witnesses over the last 5 years testified at least one other rate case just now. And because I'm not a total masochist, I don't tend to go to other people's hearings. Also, she. Wait until they come back and say that, yeah, you can say whatever you want. I'm no longer recommending, this business of having to get up at 2 in the morning and go down to the lobby.
Yeah.
Is really not conducive to health and well-being of the lawyer involved or any other business person. So, I will say, I am a little bit
I know. Well, I was thinking myself.
No, but.
Oh, I know.
No, but I mean, in terms of why we went to
Oh, I know.
we really could.
I know.
Garrett this morning.
I
and
know.
still-
It's coming up.
It's coming up.
Yeah.
It's just,
Yeah.
it's on
Yeah.
pause right now because I don't know how to refresh the machine and
Yeah,
I
it'll
don't
come
really care.
Yeah,
I didn't
saw
see
You
it.
just have to hit the, yeah, exactly.
Oh, okay. I didn't see it yesterday.
Well, it's weird.
I didn't either.
Oh, maybe I can.
You have, you have to
That might
press
be
the
the
tab,
problem.
the space bar?
Yeah.
My God. It's new technology.
All right, so then we're getting roughs
Every day. Yes, exactly. But we're getting the final of this. Actually, need to come back. She just logged.
So do you want me to tell another old friend story? Or you really tired of it?
No, this is
We love it.
So, when I started at my law firm, Ropes and Gray, lawyers not only did not have computers.
Yeah.
Well, we didn't have
typewriters.
But
Yeah,
what
but
you had was a yellow legal pad, or if you were really hip,
Yeah.
you had
Oh, a
tape
dictaphone.
recorders. Yeah,
Oh,
tape recorders.
yeah, right.
So what you would do, you would write something. Write it out.
Oh, cool, okay.
Individual admin.
Consistent, right. Wow.
So you could extend, they would just, then you would mark it up with a red pen,
Right, yeah.
and you would give it back. That's how you did it.
We didn't have word processors.
There were word
Oh, there
processors.
were.
When I was in college, I worked as research assistant to one of the professors. On the books, I think he worked at Lawrence Executive. On the books, he was using word processor, but it was like it was pretty. And the computers were had this.
Right.
Or if you, they were big computers, like they were probably computers that had this. Right? ticket.
Right, right, yeah, ding, 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 exactly. Exactly, yeah.
You'd have to borrow from people that white paint and eraser.
Yeah, white out or whatever, right?
Yeah, white out.
Alright, so by the time Dan and I finish the last two witnesses, you will have already done it again, right?
Yeah, in fact, we should talk about maybe tomorrow.
Or even this afternoon, since you're gonna have time.
Actually, when we may be
Yeah. Yeah.
I think she's gonna go through, right?
We have two more witnesses, and then the last two witnesses, unless something has changed since last night, are not physically, the last two staff witnesses cannot be here till tomorrow, so we have to go back tomorrow to have fun. And for Jess to finally get her witness.
Can you hear us today?
No, you're not at all. Well, it's like, start my cleanup, I'm gonna need to come back to it.
Well, hopefully, you will correct me if I'm wrong, but I will be old and slow.
Thank you. That one was, yeah. I should have like planned for that. When did I just put my coffee? Guys? Right, right. At 25? I don't think anyone has 25 or 26.
I am a senior citizen, and I enrolled in Medicare.
Yeah, but it's not that, like, you know.
When I crossed both those
Exactly,
thresholds,
that's what I'm saying. I was
I was
20,
like,
I think I was 25.
okay, it's time to start thinking about retirement.
It's younger, right, right, I guess you're right, that's true.
I was 20 years,
Yeah.
turning 29.
Right, yeah, when you were, yeah.
The only reason we probably would have.
Oh, yeah.
A couple of years, so like through everything.
Totally, yeah, the schedule,
Yeah,
right.
at a young age, was like 55.
Oh my God, that's horrible. Yeah, that's so awful.
Jogging. Don't take that shit. Everything they say is good. Chocolate's the only good chocolate one. Chocolate.
I have another career to go
Honestly,
back
great.
to when I stopped practicing.
Wow.
That
Yeah,
is one
no,
difference.
so that's.
Yeah, no,
Before
for
I
sure,
was
yeah,
an
exactly,
attorney, I
of
was
course.
an historian.
That changes everything.
The history
Yeah,
teacher.
but now my kids.
I can go back to writing history. For that matter, I
Right,
can go back
like,
to teaching
but I think it's good, I know.
when I'm done with this.
I know, you don't have to sell it, no.
It's true. But the only fiction I've ever succeeded in creating, and it's only in small chunks, is historical fiction. So, you know, there wouldn't necessarily be a distinction.
It's off, we learned yesterday.
Yes.
There you go. You absolutely have to do that. Yeah, I mean, yes.
Yeah, exactly.
Say again, please.
Yeah, go viral.
Oh, yeah, well, there you go. So if I time it, if I get it done and all the stars align, that might pay for my grandchildren's college
Right.
education. So it's a better, that's actually a higher probability than hitting the lottery. So, much higher. It depends on who you ask.
I don't know if
I
it's
did
five
it.
here.
My assessment is that I'm better in storytelling. I'm better verbal.
I think they,
Other people.
yeah, I think they broke the.
Writing is easier doesn't hurt. Yeah. That's true. That's true.
They are young. They're like younger than mine.
Yeah. That would probably cause me to have trial court flashbacks, though, so I'm not sure I want to do it that way just for my own mental health.
I know.
They're younger than
I know, yeah, exactly. That's what I don't like.
Yeah, I do it. I could do it into a machine.
Yeah, I don't like that. Right now, I like.
I can't actually.
And then
work
I'm like,
tape.
oh no, you're so young. Like you're so young.
Oh yeah, I mean I know the phones now. The phones now. They will talk to you on their own. They will write down what you. They will record what you say to them. All of that.
Yeah, yeah.
I am not a fast typist, but I'm comfortable. I am comfortable typing, which I was not years ago, including when I was a teacher. But I am because I've had to be because for the majority of my time at the bar has been in the universe where they put a computer on the lawyer's desk and say write it yourself. Yeah. So yeah. So I.
Right.
So there's a two.
So today we just have. Oh no.
Sure. Yeah. Well, okay. You can right. Then there are those of us who want to train their replacement
And
that they can leave.
one of my friends at grade school, the one with the energy. I think she's like the head of energy markets for Google. She did work in DC for a couple of times. But anyway, yeah, reach someone. So she was like.
There is an art to what we do
She had
in
like
this
been
profession in the
yeah.
court and briefing aspects of our profession and until they have robots like in that the iRobot until they have robots that
What do you yeah.
we've got some job security.
We can go back on the record.
Your Honor, I'm pleased to report that the parties have a proposal to formally submit to you with respect to finishing this hearing, and that is that the last two OPC witnesses, Mr. Morgan and Mr. Bidwan, appear live before you a week from tomorrow here at 10 a.m.
That sounds great. So we will make that happen. Thank you very much.
Thank you.
OBC, that's correct, right?
That's correct, Your Honor. July 28th, Friday at 10 a.m. is acceptable to everyone.
Okay, great.
Thank you, Your Honor.
I would like to bench DR the data request 29 that was just referred to in testimony, and I'd like that as soon as possible electronically.
Yes, Your Honor, we will make that happen.
Staff, I am going to be recalling witness Justy after your next couple of witnesses, after you finish your case.
Yes, Your Honor. Today?
Yes.
Yes, Your Honor.
So staff, you can go ahead and call your next witness.
Yes. Staff would call Alessandro Lee.
Can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give will be the truth?
Yes.
Okay. Can you pull that mic a little closer to you? Okay. Can you state your first and last name and spell it for the court reporter, please? You can lower your hand.
Okay. My first and last name is Alessandro Lee. My first name is spelled Alessendro, and my last name is spelled Lee.
You're a witness, staff counsel.
Thank you, Your Honor. Please state your current employer, title, and business address for the record.
My employer is Maryland Public Service Commission, located at 6 St. Paul Street, Baltimore, Maryland, 21201.
And your title?
My title is a regulatory economist.
Thank you. And do you have before you a document titled The Direct Testimony and Exhibits of Alessandro Lee, filed on behalf of the Maryland Public Service Commission in case number 9695 on June 9th, 2023, comprised of 35 pages of narrative testimony and one attachment comprised of company DR responses?
I do.
Was this document produced by you or under your supervision?
It was.
And do you have any corrections to make to this document?
I do not.
If you were asked these same questions contained in the pre-filed testimony today, would your answers remain the same?
They would.
Thank you, Your Honor. I would like to have this marked as Staff Exhibit 8.
Staff Exhibit 8 is marked.
Thank you. Mr. Lee, do you have before you a document titled The Sir Rebuttal Testimony and Exhibits of Alessandro Lee, filed on behalf of the Maryland Public Service Commission in case number 9695 on July 14, 2023, comprised of 14 pages of narrative testimony and one attachment containing company DR responses?
Yes, I do.
Was this document produced by you or under your supervision?
Yes, it was.
Do you have any corrections to make to this document?
I do not.
If you were asked the same questions contained in this pre-filed testimony today, would your answers remain the same?
They would.
Your Honor, I would like to have the Sir Rebuttal Testimony marked as Staff Exhibit 9.
So the Sir Rebuttal Testimony will be marked as Staff Exhibit 9. With your leave, counsel, what I'm going to do is in the actual record, I'm going to substitute the second version of that. That contains page and line numbers.
Yes, Your Honor.
And everyone, all parties have that, correct?
The company has it, Your Honor.
Okay.
Yes, that was emailed when I emailed it to you, Your Honor.
Okay, great. So I'm just going to, in the actual record, I'm going to substitute that. Is that okay with you?
That's perfectly fine, Your Honor.
Okay.
Thank you.
Yes. Staff Exhibit 9 is marked.
Great, thank you. Now, Mr. Lee, do you adopt your pre-filed direct and Sir Rebuttal testimonies as your testimony in this case?
I do.
Thank you. Your Honor, I would request to have Staff Exhibits 8 and 9 moved into the evidentiary record.
Any objection?
No objection.
Staff Exhibits 8 and 9 are admitted.
Thank you. Mr. Lee is available for cross-examination.
Walmart?
No cross, Your Honor.
Office of People's Counsel?
No cross, Your Honor.
Potomac Edison?
No cross, Your Honor.
Mr. Lee, your testimony is pretty easy today. I don't have any questions for you, so you are released. Thank you very much.
Thank you.
I'll go. Staff, before I recall witness Justy, please call your next witness.
Yes, Your Honor. Staff would call Christopher Lowe to the stand.
Mr. Lowe, will you raise your right hand, please? Do you swear or affirm that the testimony you're about to give will be the truth?
Yes, I do.
Okay, can you state your first and last name and spell it for the court reporter, please?
My name is Christopher Lowe, CHRISTOPHER-LO.
Okay, your witness.
Thank you, Your Honor. Please state your current employer, title, and business address for the record.
I am employed by Public Service Commission of Maryland as a regulatory engineer, and my business address is 6 St. Paul Street, Baltimore, Maryland, 21202.
Thank you. And do you have before you a document titled The Direct Testimony and Exhibits of Christopher Lowe, filed on behalf of the Maryland Public Service Commission in case number 9695 on June 9th, 2023, comprised of 16 pages of narrative testimony and 3 exhibits.
Yes, I do.
Was this document produced by you or under your supervision?
Yes.
And do you have any corrections to make to this document?
No, I do not.
If you were asked the same questions contained in this pre-filed testimony today, would your answers remain the same?
Yes.
Thank you, Your Honor. I would like to have this marked as Staff Exhibit 10.
Staff 10 is marked.
Thank you. And Mr. Lowe, do you have before you a document titled the Surrebuttal Testimony of Christopher Lowe, filed on behalf of the Maryland Public Service Commission in case number 9695 on July 14th, 2023, comprised of 3 pages of narrative testimony?
Yes, I do.
Was this document produced by you or under your supervision?
Yes.
And do you have any corrections to make to this document?
No, I do not.
If you were asked the same questions contained in this pre-filed testimony today, would your answers remain the same?
Yes.
Your Honor, I would like to have the surrebuttal testimony marked as Staff Exhibit 11.
Staff Exhibit 11 is marked.
Thank you. Mr. Lowe, do you adopt your pre-filed direct and surrebuttal testimony as your testimony in this case today?
Yes.
Thank you. Your Honor, I would request to have Staff Exhibits 10 and 11 moved into the evidentiary record.
Any objection? 10 and 11 are admitted.
Thank you, and Mr. Lowe is available for cross-examination.
Walmart?
No cross, Your Honor.
Briefly, Your Honor.
Okay, go ahead.
Good morning, or good afternoon, Mr. Lowe.
Good afternoon.
Quickly, to your knowledge, could PE physically execute the same projects that have been proposed in as part of EDIS Phase 2 without the surcharge?
Without the EDIS Phase 2 surcharge program, there'll be a risk of failing their standard because this EDIS program would provide additional improvement, so I do not.
My question is, could the company physically do the projects without the surcharge? Like, could they execute the projects engineering logistically without the surcharge?
There'll be a different cost and different reliability benefits.
But they could do the projects?
Yes.
To your knowledge? Yes. That's nothing further, Your Honor.
Potomac Edison?
Thank you, Your Honor. I have 3 short lines of cross, and the first one I would like to do is to follow up on the question you were just asked by counsel for the Office of People's Counsel. Am I correct in understanding your testimony to be that if the surcharge mechanism is not used, there could be a difference in the cost-benefit ratio for any or all of the EDIS projects, if you know?
I did not perform that analysis, but I would assume that without the EDIS Phase 2 programs, there'll be a different cost benefits percentage.
Thank you. My second line of inquiry this afternoon, Mr. Lowe, relates to one paragraph in your direct testimony. Could you turn, please, and I hope we do not run into pagination issues, but if we do, we'll get around them. The bottom of page 15 of your direct, and let me know when you're there.
I'm there.
All right, so the paragraph I'd like to ask you about begins with respect to the future filing. You see that?
Okay, yeah.
Of EDIS annual reports, and it's all caps EDIS. Cassandra, thanks. You see that paragraph?
Yes.
And you end that paragraph by recommending that the company file its annual report by November 1st. Correct?
Correct.
So currently, it's correct, is it not, that the commission requires the reports to be filed by December 1st?
I would double check the order, but I assume that's correct.
Well, are you the person, or are you one of the people who reviews the company's reports when they come in?
Yes.
And is it your recollection that all of the reports that Potomac Edison has filed under Phase 1 of the EDIS program have been submitted in the month of November, usually towards the end of the month of November.
Yeah.
Okay. And again, working from your knowledge of the contents of those reports, strike that, I'll lay a foundation. And you review and analyze those reports, do you not? You personally?
Not just engineering division. There are many divisions review your the EDIS report.
Fair enough. Do you review that report?
Yes, I do.
And you provide, and do you sometimes propose data requests to the company based on the report that's filed in November?
Yes.
Do you recall whether when the company files a report in before the end of the month of November, the company has to use some estimated data, certainly for the months of November, which has not been completed, and December, which hasn't even started, and sometimes or always for the month of October because it just recently ended? Do you recall that?
Yes, I do.
All right. And do you also recall in connection, when the staff poses data requests to the company, would you often or always be among the people who review the responses?
I'm sorry, I missed your last sentence.
I'm sorry. We've established that you are one of the people who helps generate data requests to the company following up on the report.
Generally, yes.
Okay. And you review the responses when they come back, right?
True, yeah.
Okay. And do you recall whether in the course of posing data requests to the company under the current schedule, staff often or always asks the company to update the data to include the months, as many as possible of the months that had to be estimated?
I say I do recall that, yeah.
Fair enough. And so the staff gets the data in November from the company now. Then the way it works is the staff gets the data now in the reports that are submitted in November that the company has available to it when it submits the reports in November, right?
Right.
And then the staff asks the company to update the data to the extent it can, right?
Correct.
And then the staff, before the end of December, issues its review of the report and its recommendations, if any, to the commission, right?
I would say yes.
And when the staff does that, it bases it on not only the original report, but the updated data received in response to data requests, correct?
I would say yes.
Okay. Would you agree with me that if the company files its report on November 1st rather than towards the end of November, there is a likelihood that there will be more data in that initial report that the company will have to use estimates for?
Well, just based on our experience with this filing, normally we receive it at the end of the November, and just based on our experience, staff might need additional time to review this information. So that's why I make the recommendation that the company may be directed to file the EDIS report by November 1st instead of December 1st, and that's my reasoning.
I understand your recommendation, Mr. Lowe, and as you are aware, the company has not declined to do what you recommend. I'm just trying to flesh out, and this is a small point, but I'm trying to flesh out what the real world impact will be of moving up the deadline from December 1st to November 1st. So if the company has to estimate more data, the staff will just have to pose more data requests asking for more updates. Isn't that right?
It depends on the report, like what's the question we will have to ask. But again, based on our experience, we have to submit the last-minute data request, whether it's through emails or just have a meeting, the last meeting with the company to seek the data. So that's why we want to push the filing date a little bit early.
Is staff planning to file its report, if the company is required to file by November 1st, is it staff's expectation that staff will be able to file its report for the commission earlier than it currently is able to do so?
Depends on the schedule for the administrative hearing, so I cannot guarantee.
Fair enough. So I'm just going to come right out and ask you the ultimate question that's behind this line, and that's the question: have you considered in framing this recommendation? Because step back for a minute. This is not the first time we've had this discussion. We're just now doing it in a rate case as opposed to at an admin hearing in front of the commission in December. Have you considered, Mr. Lowe, as one of the people who has to review the report, process the information, pose the data requests, and then analyze the results of the data requests and prepare a final report for the commission? Have you considered that moving the deadline from the end of November to the beginning of November may actually create more work for staff as well as for the company? Have you considered that?
I mean, it could, but again, we just need enough time to analyze this report. So again, just based on our experience with that filing deadline, December 1st, we're running a lot of problems with submitting enough data requests, performing analysis, and then submit a report to the commission. So if I recommend a November 1st filing day, will be given enough time to staff to, again, perform the analysis.
Fair enough. I'll just ask you one more question in this line. Can you recall any instances when the company has not timely responded to staff data requests with respect to EDIS?
I do not recall.
Fair enough. That's the end of that line, and I have just one more thing I'd like to do with you. So, Mr. Lowe, you're a member of the engineering division of the commission staff, is that right? The commission technical staff?
Yes.
Okay. Are you aware of the fact that the commission staff filed a report on reliability performance with the commission on Monday of this week in case 9353?
Yes, it just filed, yep.
Yes. Did you participate in the creation of any or all of that report?
I did.
Thank you. And would I be correct in stating that attachment B to that report is a set of recommended changes to certain features of or facets of the service reliability rules, specifically focused on storms?
I do not have the document in front of me, and so.
So, Your Honor, may I approach the witness?
Yes.
Let me do it.
Thank you.
And I will clarify that it is not my present intent to mark this as an exhibit. I'm using it to refresh Mr. Lee's recollection, but depending on where our discussion goes, I may mark it. So let's start with Mr. Lowe. Could you look at the document that I just handed to you, and does that refresh your recollection as to what staff included in its report and recommendations made to the commission Monday of this week in case 9353?
I believe this is included in the document as Appendix B.
Appendix B, yes, sir.
Correct.
And did you participate in the creation of Appendix B?
I did not.
You did not. Are you familiar with its contents, generally?
Somewhat, but this is outside the scope of my direct testimony, so
I understand. I'm asking you these questions as the staff engineering witness in this case. And would you agree with me, subject to check by looking at the document in front of you, that staff makes proposals with respect to enhancing the speed of restoration for storms by making it making the 50-hour rule apply to each storm individually as opposed to all storms averaged across the year?
Your Honor, I was giving Mr. Trout some leeway, but I think I'm going to lodge an objection at this point for being outside the scope of my witness's testimony. Mr. Trout is referencing prospective regulations, and I believe my witness's testimony was focused purely on the company's application. So unless Mr. Trout can bring this back to either like how my witness responded to the company's application or at least some connection thereof, I mean, I'm going to
You don't need to respond. I hear your objection. Mr. Trout has laid some of a foundation, and there is some connection at this point, so we're going to see where Mr. Trout goes with this for a little while.
Yes,
and
Your
then
Honor.
Feel
feel free to object again.
Yes, Your Honor.
And Your Honor, if at any time you want me to explain where I'm going and why, I'm happy to do that. But we can just go question and answer if you want for a while.
I'm fine with question and answer for a little while.
Yeah.
We'll see where you go, and you may hear more from me or from staff.
Fair enough.
Sounds good.
So my question was, is staff proposing as of Monday of this week to require a higher level of storm response?
I see some red line proposal in regard to restoration, but I didn't look at it in detail, so
Fair enough.
yeah.
And would you accept, subject to check, that these proposals that the staff made to the commission this week, and in which proposals the engineering division, I think you've said, participated in the creation, they include more rigorous rules on storm response, more rigorous rules on downed wire response, and a new standard with respect to availability of certain staff during storms.
Well, subject to check.
Fair enough. So taking those three, taking as your assumption that the staff has proposed that those three enhancements be adopted by the commission in the near future, would it be your professional judgment that any or all of those proposed enhancements could increase storm response expense for the utilities?
I cannot predict the cost, additional cost to perform additional, restoration under the circumstances. For example, major storm outage, you have to, respond within a certain time or percentage. I'm not sure your company's capability, like what is the cost or what's the extra personnel to carry out this restoration. So I cannot tell you.
So fair enough, and I think you may be reading too much into my question. I'm not asking for a prediction of how much costs might increase. I'm not even asking you to predict whether they will or not. My question was, could requiring utilities to respond quicker and with more personnel than they currently are with respect to major storm response, could that require more expenditures, storm expenditures by the utilities, including Potomac Edison?
Again, the company may already have the capability to carry out that restoration or whatever that would need to be done. So I cannot tell you.
Fair enough. Your Honor, I have nothing further for this witness.
Staff?
A short redirect, Your Honor.
Sure.
This Appendix B that you were just handed by Mr. Trout, containing the proposed regulations, are these regulations in effect right now?
No.
Okay, so the utilities aren't beholden to this standard as of this moment?
Correct.
Okay, thank you. That's all I had, Your Honor.
I have no questions for you. Thank you for your testimony today.
Thank you.
Staff, do you have any other witnesses for today?
Not for today, Your Honor. I believe you wanted to recall Anson Justy.
I do. I just need 1 minute before I do that.
Yes, Your Honor.
Actually, we'll go off the record for just a few minutes.
you can write it for me. Well, Jeff's been completed the whole time.
Yeah, right. You know, Jeff has been your North Star constant. Yeah, that is a real thing. Yeah, so she's, yeah, I was gonna say, no, I've never, but so she's a judge. She's a full, yeah, she's a full, just Article 3, yeah. So she has a annual party every year, like a pool party, but she calls it a pool party, but nobody's. But anyway, there's a pool coming, I feel, because she's like, no. Now, I've worked for her in 2015, 16, like, it's been a long time. You know, I thought the same thing, I was like, we're all like friends. They're all like 40th birthday parties, like, you know. Yeah, I was like, you're all children. But nothing in common. No, I was literally, like, you're like 21. I mean, that's never how she would refer to herself. Yeah, exactly. But that's how I would, yeah, I'm like, that's how, yes, that's how you're an Article 3 versus a magistrate. As a magistrate. You're Article 3 other judges. No, it's like 4 years.
Just going to wait a second until we have counsel from OPC.
And we hope that it gets. Yeah. Correct. And I'd like a committee, but. Yeah, exactly. It's great, great kid. Great kid. Great.
Did they know we were gonna restart?
Okay, we can go back on the record. So, in lieu of recalling Mr. Justy, what I'm going to do is I'm going to issue a bench data request to staff. I know there are going to be objections from multiple parties to this bench data request. And so what I'm going to do is I'm going to, hang on just one second. So I'll begin again. In lieu of calling Mr. Justy, recalling Mr. Justy from staff, I'm going to issue a bench data request to staff. I'm sure there are going to be a lot of objections to the bench data request. I'm happy to hear from you today. I'm also happy to hear from you at a later date more formally if you would like, as to your objections, as to the admissibility of what I'm asking for, as to whether or not other rate design witnesses might want to have a say in what happens, but I'm asking for some data, and we'll decide later on what happens with that data after I get it. So can I approach council table? So you've noticed I don't ask as many questions as some others. I don't feel like it's my duty to complete the record for any party. I do, however, feel like I need the evidence in the record to fully consider the issues. So that's the reason for this bench data request. You guys can take a second to read it, and I can hear from you now, or I'm happy to hear from you at a later date.
So, Your Honor, I'm unable on behalf of the company to respond to this data request. The company has no objection to your posing these questions to staff and to the staff providing you with this information. The only reservation that I would make at this time is that if, as a result of your receiving this information, you also grant other parties the right to some further additions to the evidentiary record in some form with respect to this information, as the party with the burden of proof, we would like an ability to respond not to this, but to anything anybody else purports to put in, that asks to put in purportedly in response to this.
I hear you. I understand your position. And absolutely, after we see where this goes and how the parties react, I'll hear from you again.
Thank you, Your Honor.
Your Honor, I don't necessarily object to the issuance of the request at all. My concern is that DR 29 is not currently part of the record. It is not part of the factual record in this proceeding. If by responding to this, the analysis and the data within DR becomes part of the record, I think at this stage, and I'm just sort of thinking out loud, but Walmart would want to have some means to respond in some way to new evidence being placed into the record, whether that would be another opportunity for recross or some other measure to examine the new facts that would be placed into the record.
I'm absolutely open to what you're saying and what Mr. Trout is saying. The Potomac Edison's response to staff's DR is confidential. I've received that at this point. I have not put it in. I've marked it, but I've not put it into the record. And I'm not saying I'm going to put it into the record. I want to see what update the witness has before I open this rabbit hole. Anyone else?
Your Honor, our concern preliminarily might be the briefing schedule. We just have such an abbreviated time, and we just we do have a few concerns about additional analysis that might have to be briefed. That is our only concern at this time.
Okay.
And Your Honor, just a point of clarification: what is the scope of the analysis or the format of the analysis that you want conducted? Is that just work papers, or is that additional testimony?
It would just be work papers and maybe a response to the DR that says the witness indicated that he would have liked to perform this analysis and that it may have changed his position. If it does change his position, then you can just put in the answer to the DR what that change is. I would like for it to be detailed enough that it gives the other parties an idea of what his position is, but I don't need testimony.
Yes, Your Honor. Thank you.
Okay. You'll notice that I put the deadline for this at close of business next Wednesday. If it can be done earlier, that's great, but I feel like it could take that long. We do have this afternoon open up since we're done for the day, so I'm hoping that this can be done in a timely manner and handled in a way that doesn't prejudice any party. With that, is there anything else that we need to address today?
Not that I'm aware of, Your Honor.
Your Honor, really briefly, there was some discussion prior this morning about an additional day of hearings for next Friday, a week from tomorrow. I would just like to note that we very well may have a conflict, so that doesn't change. I think I had represented before that Walmart was not going to participate in the hearing that was going to take place on next Tuesday, I believe. I just want to let you know that Walmart may not be able to participate in that hearing unless new issues open up regarding the bench's DR request.
Okay. Just one moment, Mr. Alexander. I think when you indicated that you might not participate next Tuesday, we just had the one witness, but now we've added the extra witness.
Your Honor, I believe at that point we were anticipating 2 witnesses appearing on that day. But Walmart does not have cross for either of those 2 witnesses. So I don't anticipate a problem. I just wanted to make Your Honor aware of it.
Okay. And there's always the super reliable YouTube.
Yes.
Go ahead, Mr. Alexander.
Because the issue of timing has been raised by my co-counsel, and counsel for Potomac Edison has raised the issue of whether there's a response or not. I just want to throw out there that if we're talking about time periods for the brief, as Your Honor knows, on more than one occasion, we've moved to one longer brief rather than a brief and a reply brief. So that so the single brief could be, say, 70 or 80 pages, and it could be done, say, on the deadline for the reply brief, and that could make everything more doable. Now, I'm not saying I haven't talked to our principal, and obviously other counsel and Your Honor would have to consider it. I'm just throwing it out there because I've heard from various counsel that it's going to maybe all of this mess up with the very short timing for writing the brief. So that's all. I want to throw it out there.
So I appreciate that. There's a lot to consider. Already we've moved a week late with testimony of at least two witnesses. I'm happy to correspond with everyone via email to all parties, so it's everyone's included next week as things move. I'm hopeful that Mr. Justy can respond to this DR very quickly. If before next Wednesday, if that can be effectuated, that would be wonderful. But thank you for that suggestion. That's something to consider.
Your Honor, may I address the suggestion?
Sure, absolutely.
So, first, I very much appreciate your flexibility. The principal reason, until a few moments ago, the only reason why the schedule was being changed was due to the unavailability, understandable unavailability, but the unavailability of the Office of People's Counsel's witnesses to testify when they were scheduled to testify, anytime during the 4 days they were scheduled to testify. I will be succinct. The company insists, it's not our job to insist, the company very strenuously requests the right to file a reply brief. We do not want the record to be briefed such that parties can make assertions in their initial brief to which we do not have the right to respond. So, and quite frankly, Your Honor, I would be concerned, given the history on some of these issues, that there's the potential of a due process violation if we do not get the right to file a reply brief. So Your Honor has plenary authority to create and enforce a schedule. But I want, before we spend a lot of energy on thinking about a new briefing schedule, I want to make it clear that the applicant and the party whose case this is and who has the burden of proof really, really, really strenuously believes it is entitled to a reply brief.
Okay, thank you. Anything else from any other parties? Just a moment, I see counsel conferring.
I'm not. It was just a suggestion. I've heard the company. And the only thing I'd say is that this has been done in my 15 years a number of times. It doesn't have to be done in this case. I just threw it out as an option. But I don't believe that if Your Honor did it, it's been done a lot of times and it's never been considered as a violation of due process. But that doesn't mean that I'm requesting it, or OPC, or anything else, and you've heard from Potomac Edison, so I'm going to stop talking.
So I'll just cut to the chase. It's one thing if the parties want to agree to something like that. Sounds like at least one of the parties wouldn't be likely to change its mind. But I'm not likely to go that route and to change the procedural schedule without an agreement by the parties. You're welcome to talk to each other if you come to me with an agreement. Sometimes I'll make some changes I wouldn't normally make, but okay. All right, anything else from the parties? So we can be recessed until tomorrow at 10 a.m. in this courtroom. Thank you. You can go off the record.
Thank you, Your Honor.